Trump repealed last week by executive order a law that was part of the Tariff Act of 1930, which was amended in 1938 to provide tariff-free shipment by the International Postal Network of parcels currently valued at less than $800. The threshold amounts have been raised over the decades that followed, but the law remains in place. In Trump's America, laws can be repealed not by going through Congress, but by executive order after Trump declares a national emergency, somehow related to the law that he is repealing solely on his own initiative. Republicans call that a conservative approach. It is a kingly power that King George would have envied in 1776. But wait a minute. I had ancestors who fought in the Revolutionary War as part of the Continental Army, and weren't they fighting to get rid of a king about 250 years ago? Blame John Roberts, the Chief Justice of the Supreme Court, and the other Republican justices on why this issue is now front and center again in 2025. In his executive order that in effect deletes the law on de minimis tariff-free imports in the United States, Trump claims that those parcels are used to transport illegal drugs. Maybe some of them are used in that manner, but no evidence is needed to support that claim in Trump's view, and none is given in his executive order. And there is no factual analysis whatsoever on how imposing a tariff on those parcels, which are entitled to tariff-free treatment under the law passed by Congress and signed into law by a prior president, would interfere with the shipment of fentanyl and other illegal drugs through the international postal system. I mean, what's the relationship between the tariff and the prevention of the shipment? The shipments will occur if they're occurring now. They will continue to occur even when the tariff is imposed on the parcels. About 92% of cargo shipments into the United States were exempt from any tariffs under that de minimis rule that's contained in a law passed by Congress, who has the tariff authority in the U.S. Constitution in Article 1, not the President in Article 2. By eliminating that exemption by executive order, with the Republican members of both the House and Senate remaining silent because they are subservient to Trump's will, the small and medium-sized U.S. businesses who depend on those shipments will now have to pay tariffs on them, which will be substantial, and the amount is estimated currently by at least one source as being an additional $71 billion in costs for those small and medium-sized U.S. businesses, who will have to pay tariff taxes on those small value parcel shipments now. Given the complexity of the Republican tariff taxes, and they are extremely complex, the initial impact will be chaos. That will result in products not even being shipped to the U.S. customers, which is happening now. Tariffs are sales taxes that are being imposed by a president without specific authorization from Congress. While a president acting with the powers of a king do have considerable support among the American population today, provided the authoritarian is Donald Trump and not some Democrat or some rhino as defined by Trump. The Supreme Court will ultimately decide the issue whether Trump has the authority to impose tariffs by executive order, with no votes from Congress whatsoever approving any of them, In both my videos here and in my blog post, I had been predicting that the U.S. Court of Appeals for the Federal Circuit would uphold the three-judge panel decision that Trump lacked the authority to impose the retaliatory tariffs. My new prediction is that at least 5 Republican justices will hold that he had the authority under the statute that he's relying on, that does not even use the word tariffs, or find that there has to be some kind of evidentiary hearing on whether he properly exercised his discretion in finding a national emergency that threatened the economy and national security, and that would achieve the same result as finding that he had the authority to impose them anyways. I view the 6 Republican justices of the Supreme Court to be monarchists, not conservatives in the U.S. judicial tradition, and they will likely continue creating powers for an imperial president to exercise, including the usurpation of powers vested in Congress by the Constitution, and will overrule any decision, no matter how old, that interferes with that course of action. They have created an immunity, and it was created, from criminal prosecution of a president, even an ex-president, which as a practical matter is an absolute immunity from criminal prosecution. And their decisions on gerrymandering are anti-democracy to their core and provide a pathway to authoritarian rule. Those are not conservative legal decisions that they're making now, at least in the American tradition. Stare decisis means nothing to the 6 Republican justices. They're overruling prior president left and right, and a large number of them. It doesn't matter how old they are, including a prior president like Humphrey's Executive v. United States, decided by the Supreme Court in 1935, which they refused to follow in their Trump v. Wilcox decision in 2025, and they allowed Trump to remove board members of independent agencies without any showing of good cause, in effect overruling that earlier Supreme Court decision. As a result, there is no continuity. There's no continuous constitutional law anymore with judicial decisions, at least on the hot button issues, and consequently, there are no or minimal restraints as a result of the abandonment of stare decisis by the Republican justices on new judicial interpretations that are not consistent with the previous historical ones.